program since 2012. I'm from Franklin County Municipal Court in Columbus, Ohio, and I have the pleasure of introducing our speaker this morning. Mary McClymont is the Senior Fellow at the Justice Lab, Georgetown Law Center. She's going to speak with us this morning about non-lawyer navigators in state courts, an emerging consensus. Just a few housekeeping issues. We are being live streamed and recorded for our membership or anyone else who's interested in these topics. So Mary has been asked to kind of remind us that if we have questions, which are going to be welcome, throughout the process here, either if we can step up to that mic, which I believe is already on, just so everyone at home can hear us. It's really easy to feel like we can just holler out a question. If that's not possible, if it doesn't feel comfortable, our speaker will try to summarize your question so that those at home or on the recording will be able to hear what we're talking about. So with that, I'll hand it over to Mary.
Thank you so much, Melinda, and good morning, everybody. I really appreciate your being here. It's very early in the morning, and I know you have a long day ahead of you. But really, I'm so excited to talk to you because I think your group, court managers, administrators, along with judges, are the people who would be most important in the court to get the ball rolling on something like non-lawyer navigators should you choose to go forward. And with that, let me just ask in the room, who is a court manager, court administrator? Could you just raise your hands for me so I can see? Are there any judges in the room? All right, well that gives me a good sense that so many of you are in that bailiwick, and I'm really glad to have you. I'm also wondering if any of you have heard about our study, which is on your tables, and I really hope you'll take copies of it with you. There's some more up here. Have you heard about it? Have you read it or perused it? I see a few nodding heads. But what I'm going to do is try to walk through today with you these slides we've got that really flesh out what's in the study if you've had a look at it or not. So that we're all on the same page, because after I do the slides and walk you through the study, I'd love to have some time to hear about if any of you have such a program, if any of you are thinking of developing one, and then I'd love you to give me ideas on how we can go about sharing the information and promoting it among all the critical players, across the country like you, that can help make a go of this thing. As Melinda said, as you see on the slide, our study was called Non-Lawyer Navigators in State Courts, an Emerging Consensus. This was a national survey, really just a landscape survey of what we could find that was going on specifically in the state courts of such programs that help self-represented litigants. And my colleagues up there who I list, Rebecca Sandiford, Tanina Rosting, and Catherine Aldenader, were absolutely critical to this. So we were a real team. I was also very grateful to get some support from the Kresge Foundation to help us do the study. So let's begin. What I'm going to do today is really do the obvious. I'm going to give you a bit of background about the problem as if you don't know it. Give you an overview of the programs that we found, the context for them, their goals, their methodology. Then I'm going to talk a bit about the program objectives. Why do these programs exist, and what are some of the roles that navigators are playing, so we get a handle on that. And then say a word about program implementation and the impact that we found out these programs are having across the country. I'm also going to talk a bit about funding, which is always a key situation, the staffing for the programs, and then offer up some of the recommendations that we made. Background. Like I say, let me refresh your recollections as if you don't know this deeply, because you live and breathe in the courts and know this. As the Legal Services Corporation recently found, 86% of legal problems low-income Americans receive inadequate or simply no legal help. And this is the stunner. 30 million people in our state courts are self-represented, unrepresented, whatever word you want to use. And the important thing, the third bullet there, the chief justices of the state courts, as you all know, along with the state court administrators, 2015, and it just said, hey, we want 100% access to effective assistance for essential civil legal needs. And the key terminology there is they said, let's do this through a continuum of meaningful and appropriate services. And this, the use of the non-lawyer navigators, we like to think, our study found, is just one of the tools that one could use in a continuum of services to mitigate this desperate problem we've got in our courts, where people, they're flooding your self-help centers, your courtrooms, and how are we going to help them? We know that this isn't the panacea. There's no one tool that can mitigate the crisis, but it's a good one on the spectrum of approaches, we believe. So a bit of background on the question of who are these non-lawyer navigators. Forgive the term, we can find another one. So for the lawyers in the room, no offense. For the non-lawyers in the room, no offense. We just use the term because it seemed most apt, and many people use it across the country, we found. In any event, these kinds of individuals are being used extensively around the country. In federal administrative proceedings, there's a whole category of persons in the immigration courts who are not lawyers, but they're really, really assisting to a fairly well people with immigration problems. That's an example. There are also individuals like this working in the communities. So what we really wanted to find out, but who's in the state courts? Such an important arena for self-represented people and for critical problems underway. And just to suggest to you just a couple of the things we know exist in 2 states, in the state of Washington, there's a program called LLT. These people actually can give legal advice. This is a different animal than what we were looking at in our study. But there was an authorization for them to act so that they can go into family court and help assist individuals on legal advice, with legal advice on these family matters. We talk about it in the study. There's also a program in Utah that's just emerged in 2019 where similarly, people have been licensed, they're not lawyers, but they've been trained up, and they can help individuals and give them legal advice on certain matters such as housing or family law. There are 2 states now too, and many more are starting to emerge. We hear about them every day, we know. 2 states that are exploring non-lawyer advocates in the courts who can actually go into the court. They're not outside of the courtroom, they're inside of it. And that is Minnesota. The Chief Justice has issued a ruling task force. Go out and study this for me. And they're coming back with their report at the end of this month, I am told. Similarly, Colorado has a task force underway that's looking at these kinds of issues. So it's just to give you a sense, there's now newly emerged in New Mexico the idea of let's develop court navigators among this spectrum of services that we can provide people. Arizona's looking at it. I'm from Washington, D.C. D.C. is looking at individuals like this. So just to give you a flavor of the activity underway. Okay, so let's go to our category, non-lawyer navigators in the state of courts. These are people we are talking about in our study who do not give legal advice. They give legal information and they have a very important role to play. But an evaluation was done by Rebecca Sandifer in the New York City courts, the housing courts there, several years back. And what Rebecca found was that there was a certain kind of navigator who was helping with eviction cases. She was able to determine through a serious evaluation that the individuals who were assisted in those eviction cases were not evicted. 0 individuals were evicted from their homes because of the assistance of the navigator. The navigator helped them walk through it. It's quite a stunning fact, and we don't have a lot of those evaluations, but that is one that was so determinative. And based on that study, we thought, well, gee, our little study group, let's look at all of the programs that may or may not exist that are sort of similar. As Rebecca said in that study, programs like these could be effective in a wide range of jurisdictions. Well, could they? So we sought to check that out. Just to underscore to you all, and you all are, I'm sure, a part of it as court managers, court administrators. that in these self-help services around the country, can you hear better? Could you hear it all? Did you hear anything I just said? I'm not going to repeat it. I hope you did. It's a small room. In any event, Catherine Aldenater, who's the head of the Self-Represented Litigation Network, and I see John Grecian over there, these deep experts in this field, they know and we know that there are some 250 or so self-help centers in the state courts across the country. It's a really important thing. And what we see our study doing as sort of the next step in the evolution, that we found we were studying individuals who weren't actually state court administrators per se, but were individuals who came in from the outside. So what our study sought to do was describe the current national landscape. What are the characteristics of these programs? What are they doing? What do they look like? And we wanted to do that in order to just help others who might want to develop programs to think about the elements of a design for such a program. By no means, and we say it below there, we did not seek to evaluate these programs that we discuss in the study, okay? Rebecca had done it in one case, and we didn't seek to do that. We hope others will take up that research, but our goal was to look at a set of programs and figure out what do they look like, how could one design them? And then, of course, share the information among colleagues, because that's key, because nobody's talking to each other, by the way, on this. That's one thing we found. So let me tell you what our parameters were. Let me tell you what our parameters were, how we defined our terms and the people in our study. First of all, we used the term navigator. That seemed to be evocative. It seemed to be one term that a lot of people could understand and appreciate. We used the term non-lawyers, as I told you. We use the term self-represented litigants. You may call these people customers, you may call them unrepresented litigants, and so forth. And we also use the term self-help centers as opposed to court resource centers, court help centers. I'm sure we all use different terms, but we selected those particular ones. And our definition was what you see up there. We looked for programs that were non-lawyers who were not court staff. They came in from the outside. They were physically situated in the court. That's the key. They got into the court. And finally, they were individuals who offered person-to-person assistance. We know there's a lot of great technology stuff going on. That's not what we were looking at. We were not looking at remote services. We know these individuals help people with certain tools, computers, other kinds of technology, but we wanted individuals who were offering help directly to self-represented litigants, one at a time. Similarly, further on our definition, to state the obvious, these were individuals without formal legal training. You got it. There was no attorney-client relationship. Rather, I'm just helping you for this moment in time. I'm working the case through with you. I'm not establishing an attorney-client relationship. And finally, they obviously had to be programs that were true programs, not your aunt or somebody else helping you get through the court. This was our methodology. I won't belabor it. We spent 8 months. We talked to at least 150 people across the country through our interviews. We put out a lot of calls for information about what exists, do you know what exists? And in the end, we went deep dive with about 60 key informants, we called them, individuals who either created, oversee, or manage a program. So these were varied people. These heavy-duty court administrators, judges, people who were members of the Access to Justice Commission that helped create them, and so forth. And finally, we had a consultation with some of the experts in this field to give us some counsel on how to go about the study. So here's the overview. We found 23 programs in 80 locations in 15 states in the District of Columbia. We don't pretend there aren't more. There certainly aren't less. But by our definition, that's what we were able to find in that 8-month period. We think it's a pretty good sense of it, although we know we missed programs. I want to say something about the fact that within our study, there are 3 of those 23 that are domestic violence programs. We also learned an astonishing fact that you all run into domestic violence advocates, I assume, in your courts. We know from our study that there are 1,500 domestic violence advocates working out of a court to help individuals who face domestic violence. We simply, for purposes of our study, didn't do all 1,500. We selected 3 as illustrative to give us a sampling of the kinds of activity those individuals undertake. So I just wanted to put that to the side. So 23 programs, over 60% are operational in a single courthouse. Others are distributed across the state in various jurisdictions in multiple settings. The key we found was that there was significant variability. We went into the study thinking, gee, we can come out and tell people there are these 3 models, you can do this way. No. What we did find, the 4th bullet there, is common patterns. And that's what we talk about in the study. A lot of them have similar activity or similar types of individuals, et cetera, but they develop their programs in discrete ways. And what that showed to us, and we were very excited about it, was the creativity underway in the state courts. It's such a good signal how much good work people are doing to get these programs going. We found 2 clusters, sort of programs, if you will. Half of them, more or less, were run by or supervised by court staff. They were run by the court. They often used volunteers as their navigators or Americorps members. And there were multiple case types that people were working on: family, housing, debt collection, etc. The second half of the programs, on or about, were supervised or run by nonprofits, legal aid lawyers. Paid staff were often used, or volunteers. And they usually worked on one case type, like, oh, we just do evictions. We help people with their evictions, or we help them with child custody, and so forth. The other exciting thing, at least to me, was what recent vintage these programs have. Half of the programs we found, of our 23, were since 2014. That's pretty new. Don't mean to say that they haven't existed for a great long time in some places. One of the programs we found had started in 2004, the Justice Court in California, very famous and longstanding, as well as a program in New York City that actually started in 1981. But the bottom line is these are new, these are evolving, and that's what makes it pretty exciting. We're learning from them day by day. Another thing that I think you would find of interest, very few required some sort of statute change or rule change, or gosh, we've got to have a new regulation, we need a new fancy order to do this. Not so. Rather, they were developed by, the next bullet there, multiple champions, people who came together, judges, court staff, legal aid lawyers, access to justice commissions, you know them all. And they'd work in a bilateral way. Sometimes they all came together. Sometimes it was just the judge in the court. And often it was the court staff person who said, gee, let's get one of these things going. But the good news is, and what made them very appealing, I think, is that they didn't require considerable change, regulatory change. And why not? Because they aren't giving legal advice. That's a whole different animal. That's not what we were studying. I alluded to them earlier in the program, but that's what these individuals were doing. They're providing legal information. So what were the objectives? And again, everything I'm reporting to you was told to us by our informants, let's call them, our 60 people. So we boiled down their 3 principal objectives for their programs as follows: enhancing court effectiveness, supplementing and amplifying court services, basically, helping things run more smoothly, helping the court move along faster, Secondly, facilitating access to justice for the self-represented litigants, people who are without help, without representation. That was another goal that people had. We want to facilitate this. And finally, we want to have a positive experience for navigators. Many of these navigators were individuals who were law students or graduates of college recently, or college students themselves. And this was a great opportunity to incentivize individuals, help these individuals understand what's going on in the courts, and then go out and try to help the situation later. What we found too from our informants was there's a complementarity of the objectives. Obviously, many court administrators said, gee, we want to do all three of those things. We have a goal to do them, so I don't mean that they're mutually exclusive. I thought that was a great quote of one of the judges. A byproduct of facilitating access to justice for SRLs makes court processing more efficient. That's what one of our judges said in the study. And the court administrator, very senior person, summed it up beautifully at the bottom quote there that you see. It's an advantage to courts to have navigators who help provide accurate forms, save time, mitigate the SRL volume, bring fresh perspectives, and improve procedural matters. Quite a lot of stuff. She really summed it up beautifully. It's what we found. So again, not to belabor, but it's important. These programs are about legal information, not legal advice. And our informants who've created these programs are so careful and smart about it. They have deep respect for a distinction between legal advice and legal information, and they use an abundance of caution. So that in their training guides, in their disclosure forms, and you all know this well because you do it every day, in their handbooks, in the orders that are issued, in their mission statements, they all draw the distinction. And they train up their navigators so the navigators hopefully get the distinction. Again, I've already alluded to this, but the nomenclature was the use of the term navigator, not volunteer, not member, not advocate. That's what a lot of people use, and that's great. But we lumped them together and called them navigators. All right, let's get into what they're doing. Here are the case types that they work on, and there were a range of areas. As you see it, you've got family, you've got housing, you've got domestic violence, you've got multiple case types, you've got helping with conservatorship, you've got elder abuse, you've got mortgage foreclosure. The navigators are working on all these case types. And what we lay out in this chart is how many programs are doing what. So 11 of the programs are working on but one case type. All we do is family law. Okay, great. All we do is eviction and so forth. Whereas others worked on multiple case types. And many in the self-help center, as you well know, in your self-help centers, are confronted with multiple types of cases. People come in with a landlord-tenant problem, family law problem, etc. And 9 of the programs have navigators who are confronting or interacting with all of those case types. Their roles. So what are these people doing in the way of legal information? And I really encourage you, I hope you'll take a hard copy of the study. We have a few more here, and you've seen the link online. We really dive in and explain these terms, but this will give you a sense. These are the Navigator tasks. So legal forms or documents. 90% of the programs we're working on this. Written instructions are often in play. A computer is often in play. Pre-approved forms are, but what they're doing are multiple things. They're gathering documents. They're helping people organize their documents, something you all probably are doing every day. They're preparing the documents in the sense of helping write out the stuff based on what the SRL is telling them. They're reviewing the form, oh, you missed this blank, etc. So that multiple activity under this terminology, legal forms or documents. Legal and procedural information, you can imagine 90% of the programs are doing this. What is this? This is, well, here are the courthouse rules. Here are the people in the court, like who's the bailiff, who's the judge, who's the this, that. People don't know when they walk into a court. And finally, giving people a sense of the status of their case. They may look it up on the computer. Well, you got to go to court today, or no, you don't go to court now, you go later. So really bringing to bear and helping them understand legal and procedural information. Referrals, these are obvious. Yes, ma'am. I apologize, and I didn't say that at the beginning. If it's okay, we'll wait till the end, but would you, is it for clarification?
I just wondered if, I thought helping people in Virginia, I think helping people fill out forms is legal, is the practice of law. I wanted to ask about that.
Well, it's pretty aberrant. These people, all I can tell you is in these programs, they're helping people fill out forms. And John can probably tell us more about UPL later on. But it's a good clarifying question. And otherwise, I hope we can, please do raise your hand if you have a clarifying question. But otherwise, let's really dig into some of the issues a little later after I'm done. So referrals, these are obvious. These are referring people to other court services, to legal aid lawyers, to pro bono lawyers, etc. And there are 90% of the programs that work on that. And then I won't belabor it, but they provide options guidance. They meet them at intake. They tell them, here are basically the options you have. Not what you should do, but what you can do. Language assistance, a very big deal in the big urban courthouses, as you know well, some of you from those places. Helping people whose first language is not English. This was such an important role for navigators. We heard a lot about this out of California, out of New York City, and many other locations. Navigational direction and information, 40% of the programs do this. If you don't do anything else in a Navigator program, you could do this, which is helping people simply get around the courthouse. We had a number of judges tell us, gosh, they just don't make it to the courtroom, and they default. So this would be escorting people, at telling them where something is in the courthouse, getting them a map, and the like. Court accompaniment. How many get into the courtroom? Of these programs, we found 35% of them do something within the courtroom. It may be being there for emotional support, sitting at counsel table with this SRL as he or she is going forward to the judge. In some places, there's an order that they can help answer factual questions. The SRL is confused, she doesn't understand what the judge just asked, and she's able to learn it by the navigator offering up facts to the judge, not legal arguments, but facts, or answering the factual questions. Another important role is to simply be in and around the courthouse in these heavy-duty eviction courts. That's where we found it most. People are confused. So there are navigators in the courtroom. Hello, are you confused? Let me help you. They give them certain information about an eviction case. They may refer them down the hall to where the legal aid lawyer is and available to them. They give them further information. So this is a very important role to have them in the courtroom in that way as well. Finally, about 15% of the programs do something very important, which is providing feedback. So that I notice, says the navigator, that people are confused about XYZ, they tell their supervisor, and hopefully there's a change in the practice based on what they've offered up. And again, most of these individuals are navigators for the day. They're just in and out. There's not a long-standing relationship with the SRL. I just wanted to make a point about this connecting with SRLs in the court. The navigator's tasks often comport with a particular space in the courthouse. So obviously, if you're sitting in the permanent self-help center, where many of them are, you're doing the certain kinds of activity that you would do in a self-help center. And many of them are located in self-help centers. They have a permanent location. They're in a clerk's office and the like. As I said before, it's shocking how many don't get to the court. So some of these programs have been very clever in placing the navigators in different locations. We got them at the security checkpoint. We've got them in a podium in the middle of the hallway in the lobby area. We've got them near the courtroom where they're providing the assistance, like the eviction court, the landlord-tenant court, they're over there nearby. It really helps people because sometimes they can't get to the self-help center and the like. So several of the programs, I remember Maricopa County, Arizona, have them all over their respective courthouses doing that. Training. I'm not going to delve into this here. I'm happy to answer your questions. What we do is lay out in our study the different sort of content, methodology, phases of training that are provided to navigators to give you a sense of that. Bottom line is the level of training and supervision really relates to the nature of the activity the navigator is undertaking, quite obviously. There's an emphasis in many of these programs on on-the-job training. That's where it's at. We bring them in, they read pieces of paper, they look at our training manual, but we got to get them on the job, shadowing, learning, spend 3 weeks with them that way, and then they're able to run on their own, of course, with our supervision. And finally, if a program is longer standing, it's lasting the Navigator program over a year, you've got the same navigators for a year or so, definitely follow-up training was important. Sorry. Supervision. These programs, again, have dedicated supervision. It's key. These are very responsible people running these programs. They get it. We've got to supervise people. We don't just set them off and they run on their own. The programs show flexibility in how they supervise. It's very context specific. So some have a supervisor with them in all instances. That's in those self-help centers. Others always have the supervisor available online, through email, through the phone, and very many periodic visits. So we found an array of activity, but most of it is ongoing on-site, I think in 17 of the programs. And half of the supervisors are trained as lawyers. That is to say, of course, as we've talked about earlier, these aren't attorney-client relationships, so they're not acting as a lawyer, but rather they happen to be lawyers. And sort of the other half are individuals who are really expert in housing law, let's say, and they're with a nonprofit organization or, quite obviously, court staff. In many of these cases, court staff are the supervisor, and it works very well for people. These are the people who are the navigators from what we found. 8 programs have paid employees of nonprofits. They're working as navigators. 5 of them have Americorps members. This is a very important kind of program that's in 5 programs we found. You can get funding, federal funding for these kinds of programs, and we can talk more about that. 10 of the programs use volunteers of some kind. They are undergrad or recent grads, they're law students, they're retirees, maybe they're paralegals. A lot of them are college students and recent grads, we found. And I guess then next, law students, and I think 3 or 4 of the programs used retirees. In our study, I won't go into it now, but as you can imagine, there's a lot of questions around retention, recruitment, incentives for individuals who are volunteers. And we got a lot of good insights from our informants. They told us what seems to work best for them. Funding. Funding and sustainability of the problems is, of course, the crux of the matter. It's a critical issue. There's very impressive in-kind help at play. Look at the people, the court staff in the self-help centers who are supervising the navigators, essentially in-kind support. But in a number of the programs, the reality is funding is relatively patchwork. It's ad hoc, it's hard to get, it's hard to make it work, it's in kind. That's sort of the bad news. But the good news is people have been enormously creative. And so we lay out in the study the different sources of funding the programs have found. 11 of the programs have some kind of federal resources available to them. The Americorps funding That's the Corporation for National Service, CDBG, the VAWA and VOCA acts that help domestic violence, family law matters as well. There's many more. Some of them have a line item in the court budget. Some of them get money from private foundations. Some get money from IOLTA. You know IOLTA in your respective states. The Lawyers on Trust accounts. The state bar funds a number of these programs. So there's a variety of ways the programs have been able to get started and kick off and go forward. In the study, if it's helpful to people, and I hope it will be, Karen Lash has developed a thing called the Justice in Government Project Toolkit. She lays out very helpfully all these potential federal sources of funding. And there's also a website at the National Legal Aid and Defender Association we cited in the study that suggests different state sources. So that help is on the way, help is available. Data collection and assessment, I'm not going to drill down. This needs work in a lot of places to get deeper and more complete data about who people are seeing in order to develop outcome data. But the bottom line is that without data, you can't get funding, and without funding, it's hard to get data. So this is a chicken and egg thing. And we found, though, again, as I say, people are finding ways to do this. And again, it's improving day by day. Let me close or move to closing with program impact, because this is what's quite exciting. It's amazing how the impact that we sort of talk about that, we sort of summed it up, we'll go through it, how the impact does relate to the objectives that the individuals had for their own programs. We didn't do a systematic evaluation, but we collected a lot of interesting information, which we cover in 3 or 4 pages in the back of our study. Clearly, staff talk about how this leverages court staff to meet the SRL demand. People talk considerably about how SRLs are better prepared for court. Judges talk about in our study, increasing the court efficiency. Things move more smoothly, things move more swiftly. Completing accurate forms. This is so important. I wanted to share with you some specific information we found because it's very telling. The Illinois Justice Corps, that's one of the Navigator programs, gathered data on impact of programs from the perspective of court staff. 90% of those interviewees believe that navigators improve the completeness and correctness of documents filed by SRLs, while 82% felt SRLs were better prepared for court proceedings, and over 70% felt they saved time of court clerks. So this was sort of a resounding, yeah, it's helpful to us from the court staff in Illinois. The California Justice Corps, longstanding navigator programs, they are in 3 big jurisdictions. They have 300 navigators across the state of California. They did a pilot study, and they had clerks of the court rate accuracy and completeness of paperwork that was being filed, checking on SRL court readiness and preparation as well. The sample included 25% of SRLs got served by the Justice Corps, and 75% of whom received no assistance from nobody. On a 4-point scale, 92% of the paperwork assisted by the Justice Corps navigators rated at the top of the scale for being completely accurate by the court clerks. Those who had received no help rated significantly lower, with an average of 2.3. So these folks really got in there and got some evaluative information. And I just think it shows the appreciation of the court staff meeting these particular goals of their own. Procedural fairness, the 5th bullet. This was a resounding comment by our informants. People get to tell their stories better. They feel better about it. They sit with the navigator and they walk through their story, and maybe it's a little unclear and but by the time they've run through it with the navigator, they then go to the judge. and their story flows better. They have an opportunity to really express themselves. And we found this to be one of the major advantages told to us by our informants. We have other data that I won't dig into about one of the Navigator programs was able to help save 11,000 homes in Philadelphia through a program they do on mortgage foreclosure. So we did find some specific outcome data such as that. Another thing was preparing navigators for leadership. People felt this was very important, and they were able to train up some navigators who may have been law students or college students who would go out and help do a better job and help the courts in their efforts with self-represented litigants. Legal aid lawyers and nonprofit staff found it met their SRL concerns, and there were no concerns expressed by our informants about unauthorized practice of law. They didn't run into problems, I'm happy to say. Now I'm closing with the opportunities, the breadth of activity out there, the option for the courts to amplify their services. There are multiple champions and partnerships underway. Programs show that well-trained and supervised navigators do perform a wide variety of tasks. You've seen that. Community partners are very diverse and very committed. They come from many walks of life. The challenges we've discussed, just the institutionalization of the programs. How do we get longer-term funding? How do we help sustain them? Integration into the court scene. This is always difficult, and so people worked on different ways to make that happen so that everything moved more smoothly together. Always tensions among the parties, but people talk in our study about how they overcame them. And again, we have very minimal sharing of information on these programs, and people wanted more of that. Recommendations: leaders should invest in securing resources. There's lots of champions. That's a key area of concern. People suggested to us that pilots be created, and many of these programs started as pilots. We need more measuring of the progress and collecting results, and we highly recommend that. The need to look at your own ecosystem within your own court and decide how you integrate these program components together, your self-help center, maybe there's right to counsel in your state, various other things. We also recommend a community of practice be created, and I'll tell you about a working group that we've established in case any of you want to join it through the SRLN. And finally, always, always, we need more research and learning on this subject. So I'm going to close there. And thank you very much for listening up. It was a long presentation, but I hope you soaked up some of the information. And now I'd love to ask you if you have any questions or comments. And as you, I hope, share with us your own situation in your own courts. Do you have these programs? Are you thinking about creating them? I'd love to hear from you as well. So let me just ask if you'd also please, I guess, you can walk up to the microphone if you don't want to. I'll be happy to share this with you.
And maybe this is where Virginia is, not like everybody else either. Can you hear me?
And do you want to say who you are and where you're from, please?
I'm Sally Campbell, and I'm from Virginia. I'm the manager of dispute resolution services at the Supreme Court in the Office of the Executive Secretary, which is the AOC.
Mm-hmm. Okay.
I'm just wondering whether, because we have a voluntary pilot program going on right now for eviction, that has, we're calling them conciliators. It's not our program, but we're involved. I just wondered if in any of these, if any of the courts had a concern that if this program, the judges, if this program was running in their court, any concern that the courts would seem not neutral for helping
Sure.
one side of the party, not the other.
Yeah, thank you for your question. It's very important. First of all, that's what we did surprisingly find. Among the 23 programs, that in a couple of instances, there was a concern, can we do this, can we not? This happened in Maryland, for example. And what happened was they formed a small body of officialdom, if you will. The judge, the senior judge in the court, a dean from the law school, which is where they were going to be using their navigators from, came together with a body of lawyers in the community and others, and they were able to think it through together and issue a recommendation that said, we want to go forward with this. That's how they overcame the problem. We heard talk of it in a couple of other places just as the programs got started. But the important thing we found that was nobody has been concerned. The programs have gone forward. There have been no UPL or unauthorized practice of law complaints. And I would encourage you, in the back of our study is an appendix where we list the names of the individuals who we talked to. They were very kind and let us do that. The names of their programs. And what we want to do is encourage you all to be in touch with those people if you're thinking of starting a program, if you have a concern, maybe somebody in or near your jurisdiction and the like. I can also send you off to people that maybe could be helpful to you as you think about setting up a program. But it simply wasn't an issue on these legal information programs. And I think to a degree, it's because, one, they did it as a pilot. Two, they were very careful in their materials and how they talked about the program and warning people. Three, they trained people and supervised continuously people very well. John?
Supplement a minute.
Sure, please. Yes.
This is a very real concern. And I'll tell you a place where it has come out explicitly, and that's in DV. When there are advocates who are providing help for the victim, what about the abuser? Isn't the abuser entitled to assistance from the court as well? And this has been an issue in California, where in many of the courthouses, the DV advocates actually have an office. So how do you even that up? And what the DV advocates are not going to provide help to the abuser. Forget that. You can't turn the DV program into a help everybody approach. But what they generally do is, if an abuser is seeking help or an alleged abuser, they go to the self-help center, and that's where they can get help. Another place is evictions, where most of the effort goes to the tenants, but they make clear. And this is a place where the same program provides help to individual landlords who are not represented by counsel, but say they're renting out a room in their home, and now they want to get rid of this very disagreeable tenant, and they give the same level of assistance to that landlord as they would to the tenants. There's one really far out program in the United States. It's in Maryland. In Maryland, the court system has a contract with legal aid for legal aid to provide assistance in a couple of walk-in self-help centers, but also for a statewide telephone, chat, text, email service to provide assistance to people. And in Maryland, they recognize the legal information, legal advice distinction, but they explicitly provide legal advice. They're all lawyers in the legal aid program. Even though it's funded by the courts, They are explicitly giving legal advice. Now, what kind of, there's an obvious problem here of, is the court losing its impartiality by actually establishing a lawyer-client relationship with people they're helping. In Maryland, they get around this with the Rule 6.5, which says that lawyers can provide specific advice, short-term advice, with a lawyer-client relationship, with the understanding that there is no ongoing relationship. And this has to be in a court or a nonprofit setting. And the rule says that the lawyer does not have to do a conflicts check in this situation. If the lawyer is aware of a conflict, then the lawyer cannot help the other side. But what they do in Maryland is what I would call conscious blindness. They make sure that they do not record any personal information about anybody they help, so then they cannot know that there's a conflict when the other side comes. So when a divorcing couple walk into one of the face-to-face self-help centers run by legal aid, and the two of them ask for help, simultaneously, they say, go away, and then come back one at a time. This is just so strange, where the problem is the possibility of, because of the conflicts rule, it's a race to the courthouse or a race to the self-help center, and the first one who's there is the one who gets the help, and then the other side can't get help. But by this conscious blindness, they have worked that out.
Thank you, John, and especially for clarifying the point about the fact that what these programs do is they don't say, we're just helping tenants. Quite obviously, most of the people that come to them are tenants, because typically the landlord has a lawyer. So I think it's really important to, John, really emphasize that, and that's good, that there's an alternative for people, and these programs aren't excluding either side of the case. It's just that more often than not, the people that don't have the lawyers are the, let's say, tenant. Ma'am.
Good morning. My name is Lisa Siciliano, and I'm the Family Court Administrator in Berks County, Pennsylvania. You mentioned Philadelphia. We also have some other programs in Pennsylvania and some counties where their family court has an intake, not just for protection from abuse, but they also have a intake that helps for custody and everything else, which is rare, but it does exist as a pilot in some counties. When John was mentioning about the DV and needing to have balance with the other side, one of the things we heard yesterday from the judge was about human trafficking cases. And sometimes in those DV cases, the victim is actually the perpetrator. And so if we're not having services for the defendants in those cases, we might be missing out on identifying victims of human trafficking. So a program like you're talking about might be very helpful. Another thing we have in our county that's useful, in conjunction with our Mid-Penn Legal Services, we have a modest means program where attorneys have signed on and said, for a small flat fee or a smaller hourly rate than what I usually charge, if they qualify economically, their income is just above the free legal services, but still very modest. We have a program like that. So it's not free services, but they're able to get an attorney where otherwise at full rate they wouldn't have been able to afford one. And the last point I'd like to make really quickly is this is so critically needed because clerks' offices in many courthouses, including mine, were always trained because they were chastised for trying to be too helpful and crossing that line and giving legal information. They were always chastised. So I was actually walking down the hall one day and a person was walking through the courthouse and they asked someone from the clerk's office, can you tell me where courtroom 4A is? And the clerk looked at them and said, "I'm sorry, I'm not allowed to give legal advice." This poor person looked so distraught that they couldn't find their courtroom that I was walking in that direction, and I said, "Follow me, I'll be happy to show you where courtroom 4A is." Based on that and some other things we heard, Rick Pierce from on your board and I did some training statewide on legal information versus procedural information. And we've trained magisterial district judge staff on that. And we have a sheet that we prepared that on one side says, you can do this, but you can't do that. And we have FAQs for the magisterial district judges on the questions they get asked most frequently and how they can properly answer those questions and give that information. It gives them better job satisfaction to be helping these individuals. That's why they're in the system. They don't want to be telling people, no, sorry, I can't help you. So it's very valuable with that.
Terrific examples, thank you. Yeah, we did, as Lisa suggests, find various programs that wisely develop these FAQs for their court staff as well as their navigators. And the can and should idea was another thing. Excellent suggestions. Melinda.
Would you be able to explain a little bit more about how Americorps works? So it's been mentioned, I remember it in the webinar, and I've only been able to find a little bit of information. So share how that works.
Sure thing. Yeah, so the Americorps thing is really a great opportunity. And we found 5 programs that use so-called Americorps members. There's a federal agency called the Corporation for Community and National Service. And we give all the data in our study and some footnotes if it's hard to find the link and the like. Similarly, we give links to the Americorps program. We have an extensive session on the Americorps programs. So basically what happens is there is a federal grant made, sometimes through a so-called state commission of the Corporation for Community and National Service, or it may be the federal agency in Washington, D.C. where you get your grant. You get a grant, and it's not inconsiderable. You have to put together a solid grant application, and that's what these places have done. You need a match for it. And I'm going to give you Maricopa County as an example. They have a wonderful program called PACS. It's in our study. PACS basically uses as their match court staff. They provide an in-kind match. So the money adds up, and that's how they provide their match. And what the Americorps do is it's often students who are in college or they're recent grads. Those are the typical Americorps members. They apply. They can serve for anywhere from 300 hours minimum time to as much as 1,700. That would be a full-time individual Americorps member. They receive a stipend of some kind. It's rather de minimis, but I think in the great state of California, it's up to about $28,000 or something like that now. In many places, it depends on where you live. I think in Montana, they said it's about $12,000 a year. It varies. They get educational credit in some instances. So there's a benefit to the Americorps member. They're, as I say, typically college students or grad students. And they say, I'm going to be a Americorps member, and different states have hired different levels or have gotten grants to enable them to hire different levels of Americorps members. In California, I think they have 312 or something a year. In Illinois, it's something like 50. In Maricopa County, they use about 70 in their courts per year. In Montana and Hawaii, which often have more rural court areas, they have just 6 or 7. But lots of different kinds of entities can get the grant. Typically, it's the court, where we have court-based Americorps programs, but it could also be a legal aid group in partnership with the court. So we have an extensive section on this in the study, and you'll also see in the appendix 5 Americorps programs. It's clear who's got an Americorps program, and I would strenuously urge you to talk to those individuals if you're thinking about this. I also just wanted to say that we have created a working group, sort of an online working group, through the Self-Represented Litigation Network. I hope and trust some of you are members already. It's the SRLN. And if you'd like to join that, each month we do a webinar on a certain aspect of these kinds of programs. We've done it on, most recently, on Americorps funding and how to get it. And you can hear the recording on that. And we're going to have another session on funding in May. We're going to have a session on evaluation. How do you evaluate these programs in February? So I'd encourage you to join that. And I can tell you, if you're interested, how to get to that. It's through the SRLN and to join our working group. But the Americorps program is one with some real sustenance. I think the state of California gets like $1 million a year and then has to match it. The matches differ. Sometimes it's a 50% match, sometimes it's less, especially the more long-standing your program. But it's a great way to find dollars for the program. Thank you, Melinda. Are there other questions or comments? Because I did want to ask if there's any of you who either have now a kind of similar program to what we've discussed or are thinking of developing it. Are there any of you who are in that situation? And as you think about it, I hope you'll share this information with others. I'd love to talk to you about it. But I think it's starting to catch on. And I think the more we get individuals involved in this, the more confident people will feel about it. Many of the people who we talked to in our study said to us, we really hope that you'll share this information to get the word out because it helps fortify our own program. So I encourage you to please take a copy of the study, to come up and see me if you want to talk about anything in greater depth. And I really wish you well and hope that we may see more of these programs emerging. Thank you for your time.
Thank you, Mary. Just a quick note, if you could take the time to jump on your app and give us some feedback on today's session, we'd appreciate that. And thank you, Mary, for your time.